Good morning.
Good morning.
The presentation this morning may be occasionally interrupted by the purring of visiting cats. The sound will probably be much more aesthetically pleasing than my own voice. But we're going to start today, or continue today rather, with a discussion of the federal courts. And the slide that's a picture of the current United States court. In the middle is Justice Roberts, is the Chief Justice, and the two most recently appointed justices, Justice Kagan and Sotomayor, are bottom of the meeting. I think we mentioned this last time. There are 3 women members of the court. This is the first time in history that that's happened. In fact, I think there are more than have ever been in the Supreme Court. Catholics, 3 Jews, no Protestants. It's very deeply divided ideologically. Kennedy is usually the often swing vote. There have been a large number of rulings, relatively speaking, that have been found on acts of Congress that are unconstitutional in recent years, and we talk about that later. So I think we ended last time talking about how roughly 1 more period the Supreme Court had acted to expand civil rights and civil liberties of the American people between the mid-50s and the early 1970s, and that after 1980, especially after 9/11, the court tended to swing the other way, more conservative judicial philosophy. So what the courts do, and the current situation, I think, essentially can be described as this: the courts have the authority to settle disputes between parties. Often one of those parties is a governmental body or entity. And the courts are supposed to decide cases based on facts of the case and the application of the Constitution and relevant laws. And legislators in recent years have sought to reorganize, when they seek to reorganize the courts or restrict the court's jurisdiction or limit access to the courts. And when legislators engage in a conflict over with a federal bench, we can, I think, see this as a sign of substantial political and partisan division, and that's where we are today. The Senate, for example, has been blocking judicial appointments, and then this has left these practices historically have been vacant in the lower federal courts. And as a consequence, there's been an adjustment in the filibuster rules enacted by Harry Reid, George Bush in the United States Senate. We'll talk about that in a minute as well. So we have a dual court system, which mirrors the fact that we have a federal system. There are state courts, state and local courts, and federal courts. Each has its own responsibilities for its laws and Constitution. And in theory, we have what's known as an adversarial system. So in the federal system, which is what I'm going to speak about today, not state, for the most part I won't talk about state courts. We have district courts, we have courts of appeals, and we have, of course, the Supreme Court. So most of the judges in the federal court system are federal court judges for the obvious reasons that there are not four district courts in the country. Texas makes a major point of saying that the Supreme Court is the final arbiter for matters concerning federal laws and the United States Constitution. And my view on that, in the particular case, that may often be so, but not always. And I think it's more accurate to suggest that the Supreme Court is the final arbiter until it isn't. We have that system of checks and balances. And in a few minutes, we'll talk about those checks and balances are. In a sense, the project you did on the Ledbetter Act is an example of a check and balance on the Supreme Court of the United States. Yes, Ms. Ledbetter did not get the financial award that the lower court had provided. However, the legal position that she took was ultimately enacted into law by the Congress of the United States and signed by the President. So the highest court, the Supreme Court, has appellate as well as some original jurisdiction. What that means is that while most cases are appealed and then taken up by the Supreme Court, there are a handful of types of cases that can go immediately to the Supreme Court. So I'm going to show you a couple of images of the organizational structure of the federal court system. And these courts in blue, with the exception of district courts, are specialized courts, and we're really not going to talk much about them. But you need to know they're there. And a more advanced course on the federal judiciary, we would probably talk about those, but it's not really an introductory course. So for our purposes, the main actors here are the district courts, the courts of appeals, the Court of Appeals for the Federal Circuit, and the Supreme Court of the United States. And when cases are appealed to the Supreme Court, there are really two routes organizationally that are used. On the left hand of this slide, you see the cases that would begin in U.S. district courts or federal district courts. They would then be appealed to the Court of Appeals. Then there would be a request for review under circumstances, and the Supreme Court would come and take up the case. Similarly, cases from the states can also find their way to the Supreme Court. These can go from trial courts to appellate courts to the state Supreme Court, and then the appeal route after a state Supreme Court has made a ruling. So in this case, if the Indiana Supreme Court made a ruling and the loser wanted to appeal to the Supreme Court, that would be how it would be done. And this is another example, another image of the same thing. Any comments or questions at this point? So, sticking with organizational issues in the federal court system, this image of a U.S. map shows you the boundaries, the geographic boundaries of the federal district courts and the U.S. Courts of Appeals. And so each of the regions has a number of states. So Indiana, for example, has one of the smallest districts which would include Illinois, Indiana, and Wisconsin. So what that means is the same federal courts and court for appeals will be considering cases in these three states. One of the major arguments I wish to make in this presentation is that what happens in the federal courts is political. Almost everything that happens in the federal courts is political. Yes, the judges wear robes, but this is just another political venue. The courts, federal courts, are a governmental institution set up initially by the Constitution of the United States. We talked about the legislative branch, we talked about the executive branch, we talked about now the judiciary. Each is a political institution, each is a governmental institution, though the way the various institutions are put together, what their responsibilities are different. So why is it that I say that courts are politics? And here I'm going to talk primarily about the federal courts by another name. And I'm going to list a number of reasons in the next few slides that go up to about 9 or 10. Number one, courts are political because they distribute benefits and burdens just as other governmental actors and institutions do. At the beginning of the class, we talked about various definitions of politics. One definition of politics that we talked about was politics is a distribution of benefits and burdens. Who wins, who loses, who, what, when, why, where, how. So, courts, by definition, when they make decisions or they refuse to take up a case, are making choices that affect the American people and that affect, those parties who are involved in the case. And obviously, the Miranda ruling in the 1960s, which you've probably seen some degree on TV contact shows. So, police officer arrested, but you have the right to remain silent, you have the right to an attorney, anything you say can be held against you in a court. The Supreme Court ruled that in a particular case, Miranda v. the plaintiff, that his conviction was overturned because he was not given that warning by those officers who arrested him. Well, that ruling applies to every single police officer, at least in theory, and every single person who's arrested in the country. It has since been limited by subsequent court decisions, but in fact, it's still the law. So that's an example of a case where the decision literally affected tens of millions of American citizens. Secondly, courts are often involved in major political and policy conflicts. So, of course, they're involved in politics. From your own research, you know that the courts, sometimes state courts, sometimes federal courts, have been making decisions with respect to gay men. And that issue is and has been a major policy conflict in recent years. It's likely that if the courts hadn't made the decisions that they've made now time after time with respect to gay men, that it would still be illegal in almost all the states. And so the courts were a major force for policy change. Even in, just in the past year or two or three. Thirdly, we may tend to think, this comment refers back to what I said a moment ago, we may tend to think that judges make the final decision and are to be obeyed. But that's not political reality in the United States of America. The reality is that people appeal judges' rulings. They see sometimes those made or block those rulings. And they even seek to have them overturned by other actors. For example, the president or some executive branch or by the Congress. And again, the Lilly Ledbetter Act is an example of a relatively recent Supreme Court decision where Congress said eventually, no, we're going to overturn that decision. We're going to reverse that decision. We can't see that Lilly Ledbetter has her due, but we can see that everyone similarly situated in the future is protected and has legal rights that the court wouldn't give. And so that law and the decision, while it holds with respect to Lilly Ledbetter, is not applicable to in any other case, presumably because of the passage of that law. If you understand the way federal judges are selected, one also has to conclude that this is very much a political process. The president, of course, appoints or nominates federal judges. Those judges have to be confirmed by the Senate of the United States. So very briefly, the way the process works is first, presidents and their advisors are usually selected senior level Justice Department officials go through an elaborate process to screen, to nominate, and to prepare for the confirmation process. President's office needs to place close associates and or those who share their political views and party affiliation on the federal bench. All that is to say Democratic presidents tend to nominate Democratic nominees and Republicans similarly. When president nominates a candidate for the federal bench, the first consideration is almost always the party affiliation of the candidate. Not always, but often. And members of the president's party are generally involved in the process as well. Keep in mind that the Senate has to confirm nominees. Because the Constitution gives the Senate that role, one of the things that has been established in the Senate is what's called the norm of senatorial courtesy. This norm gives senators, especially those of the president's party, an opportunity to contest and even veto potential nominees. The way this works is that when a federal judge is from a nominee, is from a specific state, the president or his advisors will consult senators from that state. Sometimes the president or his advisor will ask senators from that state, do they have someone in mind? Obviously, Democratic presidents listen more closely to Democratic senators. Republicans listen much more closely to Republican senators. But so this is a partisan process that involves a kind of the vetting process includes executive branch consultation with the senators, especially the senators from the state where the federal judges serve. Another example of politics in federal courts is that Democrats and Republican presidents tend to nominate people in demographic terms. About 40% going back to President Clinton and President Carter all the way up till today, Democratic presidents tend to nominate somewhere around 40% of the candidates who are women and minorities. Republican presidents, on the other hand, overwhelmingly appoint white women. So, put in different terms, Democratic presidents still nominate somewhere around 60% of judges who are white males, 40% are women or minorities. And the Republicans, I don't know the exact numbers for Republican presidents, but probably not any higher than 10% of women and minorities for Republican presidents. So the Senate has a critical role in the confirmation and the seating of federal judges, including Supreme Court judges. And for almost 50 years now, there have been many conflicts in the Senate over the confirmation of presidential nominees to the federal bench. This really began, in my view, in the late 60s with the case of Justice Abe Fortas, and where the Republicans sought to prevent his confirmation as Chief Justice. And in fact, they actually forced him to resign from the Supreme Court. He was a nominee of President Johnson, and they're the close associate with President Johnson. And because I would argue involved in the Fortas case, subsequently, that was the impetus for the increasing number of partisan battles in the Senate regarding the confirmation or even considering the confirmation of federal bench nominees. One way this has been done most recently is through the role of the filibuster, and if the president is of one party and the majority in the Senate is of another party, it's been common for the other party to simply not consider many of the president's nominees. This has left a lot of vacancies, an unprecedented number of vacancies in the federal court system that has been criticized by more than one Supreme Court Chief Justice. So this year, Majority Leader Harry Reid ratified the Senate filibuster on judicial nominees. Up until that time, in order to get a vote on a presidential nominee to the federal bench, the majority leader would need to find 60 votes to stop the filibuster. Again, that's called cloture. We spoke about that when we talked about Congress. So the compromise that Majority Leader Reid proposed and put into effect was that the filibuster rule in the case of nominees to the lower courts in the federal system would be eliminated, but that it would still be allowed for nominees to the Supreme Court of the United States. And his hope was that it would speed the process of consideration. Actually, not just speed the process, but make the process even worse, so that judicial nominees in the appeals and courts and district courts could at least get a vote, up or down. Courts are also political because the idea of an independent judiciary is in some measure a myth. Judges don't look like other people in politics, at least when they have their robes on. But they still socialize with political and economic elites. They go duck hunting with vice presidents. I'm referring, of course, to Justice Scalia and Vice President Cheney, who socialize. They belong to the same clubs, not just these two, but many judges and people in Congress and the executive branch. They belong to the same clubs. They went to the same universities. They even give money to the same political candidates and speak at some of the same meetings and conventions. It's probably the case that most judges credence to this fiction of an independent judiciary, and that they try to look at each case somewhat objectively. While that's what they're trained to do, their interpretation of the key issues and the desired resolution is almost always substantially shaped by their own life, political values and commitments. And frankly, it could hardly be otherwise. It's not easy to move into or be placed into a decision-making role and somehow forget everything that they ever thought, learned, or experienced in their life. It's just too much to ask. Human beings are not robots, they're human beings. Another sense in which the federal courts are political are played in what we call amicus curiae briefs. When the Supreme Court or other federal court agrees to hear a case that various groups consider important or of vital interest, they will file what's called a friend of the court brief. That's what an amicus brief is. It's a friend of the court belief. So we talked about Congress. We said lobbyists work on legislation or try to obtain favorable legislation. Well, various actors, interest groups, businesses, associations are free to submit friend of the court briefs to judges in the United States. In the first case, that is in the case of the legislative branch, there's a talk about policy and what law should be passed and what the provisions of the law should be. In the case of the federal courts, this is reconstituted into what might be called legalese. In other words, a brief is a legal document. It is a brief regarding a specific case and the reasoning behind legal reason why a case should be decided in a particular manner. So both interest groups and the Justice Department and many other organizations present to the court their legal reasoning for a decision in one or another case. In major cases attract a huge number of legal arguments. Amicus briefs, much as political actors seek to influence Congress on important legislation. And so a cynic might say, well, amicus briefs are just kind of like, the equivalent of legal lobbying. And so this in fact is another example of how the federal courts are deeply embedded in politics. So here we have perhaps one of the last arguments for why on the Supreme Court there's politics, and that's called small group politics. In this image over on the right are 4 examples of influences on the decision process in the Supreme Court. The Supreme Court determine the pattern of cases to be considered. The interest groups and the Solicitor General, who is the chief representative of the federal government for the Supreme Court, may also file amicus briefs. And law clerks are important because justices on the Supreme Court do the bulk of the research and writing in the decisions that the court makes. So this is a politics of small group dynamics. Here we have a relatively, at least with respect to the Supreme Court, we have a relatively fixed number of people, 9 Supreme Court justices. They'll have their law clerks. We have a handful of other regular actors like the Solicitor General of the United States. But the relationship between the 9 Supreme Court justices is very important. I'll try to explain why in a minute. First of all, in order to hear the case, the rule of 4 generally, if it's a case that's appealed to the Supreme Court, the rule of 4 generally determines which cases the court will hear. In other words, 4 justices have to agree, or the 9 have to agree to hear the case. We mentioned the Solicitor General. He's the top, or she's the top Justice Department lawyer. The Solicitor General can affect the Supreme Court justice simply because he or she is the lawyer that is most often seen by the court. We talked about how law clerks play. That's down here on the slide. I'm not going to move on yet. I need to explain one other important piece of the small group politics of the Supreme Court. And it's, for some reason, I think I didn't put it on any of the slides. One of the critical small group for the Supreme Court is who is going to write the majority opinion. Sometimes that affects what the majority opinion will be, or even whether there will be a majority. So, in the case where the Chief Justice, who is now John Roberts, in the case where Justice Roberts is in the majority with respect to a specific case, the Chief Justice then determines who writes the opinion, the majority opinion. But sometimes the Chief Justice may not be in the majority. And when that happens, the senior justice who is in the majority gets to determine who is going to write the majority decision. So there is some degree of power associated with the capacity to determine who writes the majority opinion within the Supreme Court. One other point that should be made, and that is that the justices do have specific areas of legal expertise and infrequently assignments for writing majority opinions go to those with the most expertise in a particular area. But keep in mind the issue of whether the Chief Justice is able to determine who's going to write what can be an important element in small group politics. So when does the Supreme Court take a case? What kinds of cases does it take? Nobody has an absolute right of appeal to the Supreme Court. There has to be an appeal that has to meet certain conditions, even when those conditions are met. 99% of the time, the court doesn't take a case. This goes back to our discussion last class before Thanksgiving. The Supreme Court considers and actually rules on a very, very, very small percentage of cases that are appealed. So it's around 1%. What would incline the court to take a case? One would be there are differing rulings at the lower court level. So different courts have ruled in different conflicting ways, and those conflicts need to be resolved so that we know what in fact the law is, at least for a time. Another situation that might incline the Supreme Court to take a case would be if there are lower court rulings that conflict with previous Supreme Court rulings. A third factor might be a case that has a broad significance. And the fourth factor that would influence the court, and these are the only four, but these are four, would be the appeal by the Solicitor General against the Chief Legal Officer in the Justice Department, who works and cases before the Supreme Court. And then, of course, the Supreme Court does have the power to exercise the power of certiorari. This is when it actually instructs the lower court to bring the case to the Supreme Court and the rule of law, which would court the rule of law. So those are some of the considerations that would the case to get before the United States. When the Supreme Court makes decisions, it can make various kinds of decisions. And we'll talk first about opinion and then decisions. So the Supreme Court opinion can affirm a lower court ruling. So an affirmation affirming a lower court ruling holds previous ruling and rejects the appeal of the party the loss in the lower court. Second, Supreme Court opinion can reverse or overturn the previous lower court decision. And that's, of course, just what happened to Lilly Ledbetter. Thirdly, the Supreme Court can decide to remand or send back a case to the Supreme Court. We're not going to hear it. We're not going to deal with it. And finally, the court can issue an opinion per curiam in which the decision is simply made by the court, issued by the court, or at least the majority of the court acting collectively, and often. Now, judges write opinions. These are not typers of judge opinions. These are types of judge opinions. It's interesting that I have a typer or a typo right there. So judges can write opinions. They don't have to in all cases, but they can. So one type of decision and opinion by the unanimous court. This is where all 9 judges sign on to the same opinion, whatever that opinion is. The second type of court opinion is called a majority opinion. And a majority opinion is when 5 or more, but less than all of the justices who write an opinion. If a case can be decided one way or the other, without a majority agreeing on the legal reasoning for the decision. In those cases, the ruling by the Supreme Court does not become a precedent. In order for a ruling to be a precedent, a majority of the court, in other words, at least 5, have to agree on the reasoning of the majority opinion. But sometimes justices don't agree with the legal reasoning of the majority opinion. They agree for different reasons. And so they issue a judge who's in that situation can issue what's called a concurring opinion. The concurring opinion is one where the judge says, I agree with the way the majority of the court I agree with the majority decision on this case, but I disagree on the legal reasoning for the decision, and I think the decision is made for other legal reasons, so I'm writing this opinion, which expresses my view. So essentially what a concurring opinion says is, yes, the majority got it right, and then there are those in the minority. 4 or fewer justices. And if a judge feels strongly about his or her opposition to the majority decision, he or she can write what's called a dissent and explain in that dissent what the ruling should have been and the legal reasoning for that. So a dissent says, you got the decision wrong, and here are the reasons why you got the decision wrong. I think this is a good place to stop. And welcome back to school after the Thanksgiving break. And see you tomorrow morning.